An uncontested divorce in Arkansas is between two parties when they've reached an agreement on all essential terms that can save time, money, and reduce the emotional damage that divorce has on families. This is a significant moment not only for husbands and wives, but for children as well. And while divorce is never an easy decision, the approach taken here is one of cooperation, fairness, and respect for both the legal process and each other. So I'm going to walk you through the essential components of an uncontested divorce, which include the proper filing of the divorce papers, the procedural requirements, the division of property. We'll talk about custody, support considerations, and other legal factors such as spousal support. My name is Leon Jones Jr., and I've been practicing in all courts in Arkansas, as well as corporate law and state government for over 15 years. And now I'm the managing attorney here at Big Rock Legacy Law Group, where we help our clients with estate planning, business law, family law, and litigation. The first and perhaps most important step in any uncontested divorce is making sure that you comply with all the procedural requirements here in Arkansas. Now, these are clearly set forth to protect both parties and to ensure the validity of the court's eventual final decree. Let's talk about the petition for divorce first. That petition has to be properly drafted, it has to be accurately completed, and it has to be filed in the county where the person lives who is filing for divorce. Now, that person is called the petitioner. Again, the person that's filing for divorce. The petitioner has to satisfy the residency requirements, meaning they have to have lived in Arkansas for more than 60 days before they file for divorce. This provides the court with proper jurisdiction to hear not only the issues, but also to resolve those issues in court. The divorce papers have to be served on the other party. Service can be completed when the other party gets the papers in mail, or those papers are delivered by a sheriff or process server. Now, this will eliminate any dispute over whether they got notice and making sure that the proceedings are fair. Both parties must be fully aware of the petition and the terms of the divorce, which brings the final decree into play, meaning this is the document that outlines all of the agreed terms. Now, this document cannot be presented to the court prior to 30 days after you file for divorce, meaning once that 30-day period is up, the divorce can be finalized and the marriage can be dissolved. But let's talk about the decree, which has to include all the elements between both of the parties. They have to be set forth clearly and completely. Doing this prevents any ambiguity and future misunderstandings and disputes. Now, when you carefully adhere to this process, it will underscore the seriousness with which both parties should approach the dissolution of their marriage. So let us here at Big Rock Legacy Law Group assist you. Click the link below to schedule a call, and let's get started. Now, let's talk about property division. Arkansas follows the principle of equitable distribution. That just means that it's not necessarily equal, but it has to be fair. And this has to take into account the circumstances of both spouses. So therefore, both parties have to fully and completely disclose all their marital assets, as well as the debts, so that they can have an honest and transparent picture of what they're going to divide. This disclosure includes real property, it includes personal property, any financial accounts, retirement accounts, as well as other debts and liabilities. So what's the difference between marital property and separate property? Well, the parties have to understand and know what that difference is. Marital property, which is subject to be divided, is different from separate property, which was acquired either before the marriage or through an inheritance. So basically, separate property remains with the individual to whom it belongs, while marital property has to be divided equally between both parties. Now, after a full review and both parties have reached an agreement on what the distribution should be, and that distribution has to be balanced and equitable, the agreement should then reflect not only that in fairness, but also it should be practical. It should recognize each party's contributions during the marriage, as well as their individual needs going forward. This solution or resolution should ensure that neither party is left at a disadvantage, and that the property rights are settled conclusively at the time of the decree, so you won't have to come back and fight over anything in the future. Now, one of the most sensitive areas in any divorce, of course, involves the children. Arkansas law emphasizes the best interest of the children above all else. And in an uncontested divorce, there's no exceptions to that. The parties must have jointly developed a comprehensive parenting plan. Now, this plan has to satisfy custody arrangements, has to satisfy visitation schedules, and make sure that there are clear decision-making responsibilities by both parties included in the plan. Most importantly, the plan has to be structured to provide stability, predictability, and ongoing meaningful relationships between the children and both parents. Child support has to be calculated according to the Arkansas guidelines. And this takes into account the income of both parties and the needs of the children. So the agreement should ensure that support is fair, it's consistent, and is sustainable so that the children's welfare is fully protected. So when you take this approach, that will allow for the marriage to end in a bit more amicable agreement and that the parenting partnership will continue for the children. Both parents must remain committed to the children's growth, to their safety, and to their well-being. While property and custody form the foundation, there are some additional matters that need to be addressed to make sure that this divorce is complete and fair. Both the parties need to review whether their spousal support is appropriate. Arkansas law considers factors such as the length of the marriage. It considers factors such as each party's earning capacity and their contributions made during the marriage. So based upon these considerations, both parties should try to reach an agreement that reflects fairness while supporting the other's ability to move forward independently. Legal representation in an uncontested divorce should be considered, and each party should be given an opportunity to consult with their own attorney. So this will ensure that both sides are fully and completely informed of their rights and that they have those rights protected. There are always the potential for disputes, and those disputes can and often should be settled through the mediation process rather than the litigation process. The collaborative nature saves time, it reduces costs, and most importantly, it preserves the stability between the parties. By addressing these considerations, the parties can ensure that their agreement is comprehensive, it leaves no loose ends, and it reduces complications for future enforcement. Make sure you subscribe to our channel to learn more about how we help clients every day here at Big Rock Legacy Law Group.